Hey there, this is Mark News, Westward Law. I'm here to talk just a little bit today about what happens when you own a house and you got a bunch of equity in it, and what happens when you file for bankruptcy if you do. If you need to, then hopefully it's a tool that's available for you, but there are some limitations. You are allowed to have a certain amount of equity in your house that you can protect in bankruptcy generally. In a Chapter 7, you can protect it just as much as you can in a 13. Now in a 7 you need to be up to date on your payments and that sort of thing. But there's, in Washington here, we're in Washington State, and this is one of the areas in bankruptcy law that state law can come into play. And in Washington State, if you qualify and you've lived here long enough, you've been a resident in Washington for a long enough period of time, then you can claim the Washington exemptions. And under Washington state law, you can generally exempt up to $125,000 of equity in your house. And that's nice. I mean, you want to be able to protect that, and that'll be basically a nest egg or something that you could possibly borrow some money against after the bankruptcy's over. It's something there that can allow you to have your fresh start, something to fall back on. Under federal law, the federal exemptions, which is another body of law that many people do use, even in Washington, we have a choice here if you've lived here long enough. The exemption is not as large. There's some other aspects of the federal exemptions that make it actually pretty good for most people in bankruptcy. But if you have a lot of equity in your house, then possibly the federal exemptions are not going to work. So you want to use the Washington exemptions. And hopefully the equity isn't any larger than $125,000, because then there could be a problem, obviously. Yesterday I was down at the bankruptcy court in Seattle, and we were just getting some updates on some new cases that have come through the courts here in Washington, and then up through the Ninth Circuit. And one of them has to do with Washington exemptions, and for the homestead, for your house. So how much can you protect under Washington law? This is a very, very interesting case law there that's being worked out here recently. And I guess it depends on which side you're on, but it wasn't the best news, I don't think, for people that are trying to protect equity. So one of the big issues is if you file for bankruptcy, on the day you file, that's when the line is drawn, and whatever the value of your house is on that day is what gets recorded, and that's what everybody's marching to. And so if your house had on that day less than $125,000 worth of equity, then you're probably all right, But what happens if we're in an environment like we have been here in Seattle for the last several years? I mean, things are starting to slow down now, which is a good thing, I think, but it resulted in situations where people would file for bankruptcy, and then after the day they filed, there would be a lot of appreciation in their house. So if they, on day 1 or day 0, had $120,000 of equity in their house, and they're probably okay, it can protect that. But then what happens 3 months, 4 months down the line, while the bankruptcy is still ongoing, if the market is just going straight up and there's a lot of appreciation in that property, what if now it's worth $150,000? Just in the course of 4 months, maybe it went up $30,000 in value. And that leaves you in a what would normally be a better position, right? You have more equity, but now you're exposed because your house has this extra equity sitting there that a trustee might see as something that they ought to go after, because if they can get that $30,000, or it might be something less than that after they take out the cost to sell the property, that kind of thing. But would they want to go after that additional equity so that they can pay that money to the creditors? On day 1, the house was fully protected, but then now 3 or 4 months later, should the trustee be allowed to come in and work with that house, possibly even sell the house so that they can get to that money to pay the creditors. You know, and obviously the debtor's going to get their $125,000 because that's protected, but this additional amount is what's at issue here. And you know, no debtor wants to have a house, you know, sold out from under them when they thought that they were good. So that's the nature of what we were discussing yesterday, and I think you know, there's still remains to be seen how all that's going to play out. But I mean, for all intents and purposes, any kind of appreciation in the estate after you file for bankruptcy belongs to the estate, which means that the trustee can then start thinking about what they want to do with it, and that's the outcome of these cases so far. I found it fascinating. I don't know if everybody else would, but for me it was pretty fascinating. And while I'm not a big fan of the outcome of it, it was enjoyable to sit and listen to some of the experts talk about it down at the Seattle Bankruptcy Court. Anyway, I just wanted to touch base and say hi, and until later, this is Mark News at Westward Law.